Already, the first application today was done for you to make a ruling. Of a matter that has not been heard inter partes. This was an attempt to adjourn this matter. Having failed to adjourn that matter, the court directed the matter proceed substantively. The prosecution has now made an application for an adjournment on two grounds. One, arms register is not before this court. Nobody is explaining why it's not before this court. Where is it? Who has it? What are the circumstances for that person not to bring the exhibit to court? Lady, this raises a very serious constitutional question. IPOA is the investigating agency in this matter. The chain of custody of exhibits.
She sought an application for an adjournment.
I want to lay the basis. My lady. I'm raising.
I don't think we have reached where it is not available. So that if it was not available, I would simply say it will be in your favor. So I think I want you to, because the key issue for determination is, she's saying it was not availed. She did not say it was missing. She did not say it was missing. Just a correction, counsel.
It is not availed.
It was the witness, the OCS has not availed, and he promised. I'm only redirecting you to what he
And
said.
I'm heading to the OCS.
But must you go to Mombasa through Uganda?
No. Let me deal directly. What they fear me talking there, I'll talk it here in court.
Okay.
Yeah, because it will still go on.
You raises constitutional question on?
Constitutional questions on the custody of exhibits.
Okay.
The OCS is an employee of the National Police Service. This matter is not being investigated by the National Police Service. It is IPOA. The custody of exhibits, that's the chain of custody of exhibits, must be with the investigator.
Are they saying it's lost?
I'm not talking, they've said the OCS.
The OCS has not brought
Yes.
although he promised to bring.
And I'm raising a question. How did the OCS have custody?
Okay. I get you now.
That's the question. The OCS has no constitutional or legal mandate to have custody of exhibits of IPOA. The complaint before this court is against an employee of the National Police Service. The gun in question and the arms register are documents in possession of the National Police Service. The framers of the law gave IPOA a constitutional and statutory mandate to investigate misuse of firearms by members of the Kenya National Police Service. If by admission IPOA is saying they are not in custody of the exhibits, it is a dereliction of their duty. And therefore, my lady, any explanation that arms register is not in the custody of IPOA goes to the root cause of procedural issues on how evidence should be kept, the chain of custody. You know, this, my lady, this question I'm raising is going to be thunder, because IPOA should by now have their Omari. By now. And they keep all their exhibits. And it is therefore my submission, my lady, that IPOA have the arms register. Let them explain why it is not here. Not the OCS. Number two, my lady, we were briefed yesterday by the prosecution who the witnesses are who are coming today. The state is telling you that one witness has refused or is not available from CAK. The state knows issues of seeking for summons. When it fits them, they forget the law. So the question about somebody refusing to either come or to pick the phone, that is a question to be balanced against the rights of an accused person. My lady, if an accused person failed to be in court today, warrants, the state asks immediately warrant of arrest. We shall be asking the court to be fair on that. My lady, the third issue, when we appeared before you the last time, we pleaded with you, you wrote a letter to the CJ to allow you to sit over vacation. We moved with this matter expeditiously. And the directions the court can check were that all the remaining witnesses be brought for this matter to be concluded. As I indicated earlier, and that is what my colleagues don't want me to tell the world, they achieved what they wanted by charging him. They are not ready to prosecute this matter. My lady, if you look at this matter, I think Your Honor, it is either a 2021 or 2020 matter, 2023 matter, but the incident happened around 2017. My lady, this matter has been adjourned 3 times at the instigation of the prosecution. And I repeat in court that this is a matter being driven by civil society, not the prosecution. And that is the fear. They don't want anybody to be told out there. The court record should see if the accused person has ever failed to be in this court. The accused person has religiously attended. The question about the arms register, this is not the first time. Adjournments have been granted by virtue of that missing or unavailable register. So my lady, there is no sufficient reason presented before you to warrant an adjournment. In the morning, when we had a call-over, the state confirmed it has witnesses to proceed. Based on that, the court gave firm directions. This matter will proceed today at 11. Only to come a first attempt to adjourn, that there's a ruling. Now, it is now clear to the court the character, not of the accused person, but the character of the bench prosecuting this matter. Instead of prosecuting the matter against Ahmed Rashid, they want to prosecute against Danstan Omari, the advocate. I'm not an accused person. Let them proceed with this matter and produce evidence against Ahmed Rashid. My lady, it is my prayer. This is a matter of 2017. Give directions, this matter to proceed. For the end of justice. My lady, nowhere is the state blamed whenever there is a delay in a matter in court. The public blames the judiciary. And yet the judge is here every time ready to proceed. The accused is here every time ready for the matter to proceed. The state is the one that causes a backlog. But the blame goes to the judiciary. Let them carry that burden today, and we clean the good name of the judiciary. This matter has not been taken out from day one due to the court's absence. It's because the state is not ready. My lady, an accused person is the darling of the court.
The constitution of the constitution, not the court.
Of the constitution?
Yes.
Yes, yes. He's the darling of the constitution.
The court is impartial.
Yes, yes,
yes. Yes.
Article 49 and Article 50 of the Constitution have been made to protect and safeguard Ahmed Rashid's rights against the excesses of the state. And this is a serious indictment, my lady, that should be taken to the bosses of this prosecution team, so that we know whether it is a policy from their bosses or it is somebody trying to misuse and abuse the criminal justice system. My lady, the casual nature of the application to adjourn, and they know very well the next date this matter, I've heard that court diary is talking of June, July. They know very well. The court is full, the diary is full. My lady, may you make a finding that is bold and clear. This matter to proceed. The witness, one witness is present. He can take the dog. He can be led in examination in chief. He can be stepped down for them to bring that exhibit that they think or they know that they have, but they have refused to bring before you. And I'm also requesting that I'm not trusting whether that one witness is in court. Let the court see physically if that witness is present. Because
Miss, where is the witness? Can we see you?
Alan.
What? This one of Miss Omari, I only see on TV. And
you know that's why they block us from telling the public what they do.
Let's see Mr. Alan, please.
Let him take the dog and explain to the court.
Had the submissions by both the prosecution, defense counsel, and counsel watching brief for the victims. I wish to state at the onset that under the current constitutional dispensation, the victims have a right to be heard under Article 50, Sub-Article 9 of the Constitution. Victims are no longer passive participants in the criminal trial process. They have a loud voice, and therefore counsel from Amnesty International and IJM are properly on record for the victims. It is also not prejudicial if they are the drivers of this case because they represent victims. They can't drive without honking and making noise along the road. The victims' counsel are therefore at liberty to continue driving the prosecution counsel to ensure that justice for the victims is done. So I don't understand why the victims' counsel do not want to be seen as driving the prosecution. That is your duty under the Constitution and international law. Having said so, I agree with Mr. Omari that this case has taken too long. It is not it is not in dispute, sorry for that. It is not in dispute that the accused person has been interdicted by his employer. The prosecution counsel should therefore have left the officers and their offices rather, and moved to communication authority offices to ensure that the witness attends court. They cannot sit in the comfort of their offices and expect that the witness will attend court, yet they know very well the witnesses were not responding to their communication. It is a failure on the part of the prosecution case. Further, that Pangani Police Station has not availed exhibits is not an excuse at all. Pangani is a stone throw away from this court. If indeed the prosecution was serious about getting the exhibits today, when the court set the matter for hearing at 11, the investigating officer should have driven to Pangani Police Station and taken the exhibits and brought to court. It is not the OCS to bring the exhibit to court. It is not the OCS who is supposed to testify. The witness was supposed to testify as to the exhibits was in court. Therefore, it is a failure on the part of the IO and not the OCS. So that is not a reasonable excuse for an adjournment. I agree with Mr. Omari that the reason for adjournment is not convincing at all. However, there are victims in this case who are interested in the substantive justice of the case. Failure by the prosecution to avail witnesses cannot be visited upon innocent victims, and to force the prosecution to close the case prematurely today would actually be a disservice to justice, and it will not be in the interest of justice to the victims as well as the public at large. Also, forcing the prosecution to withdraw the matter under Section 87A would be an exercise in futility, as the accused person will just be rearrested outside this court. We've had 19 witnesses. Rearresting the accused, starting the case afresh, it means that those 19 witnesses have to be recalled. So what is the best way forward? For the above reasons, the application for adjournment is adjourned. The prosecutor, Ms. Fuchaka, you must learn the best practices of Kibera High Court through case management. Learn to communicate with the court, learn to communicate with the defense counsel. Had you communicated that you are having trouble, Mr. Omari would not have come to make a serious objection in this court. We would have adjourned the matter virtually. This precious day has therefore been wasted due to lack of prosecution and investigative diligence, but I agree with the prosecution case, counsel rather, that the case should be adjourned, and I hereby adjourn.
Much